Welcome. Today we are taking up one judgment of the Supreme Court. It is AIR 1994 Supreme Court 853 titled SP Chengalvaraya Naidu versus Jagannath. This judgment is about the fraud as it is taken in the eyes of law. It is in the nature of fraudulent pleadings. And the fraudulent pleadings are in the form of concealment of material fact. Therefore, we as liars have to be much vigilant as that concealment of the material substantive fact from the pleadings will amount to a fraud, and the implication of it is very big. Now, this judgment of Justice Kuldeep Singh, Honorable Justice of Supreme Court of India, in a way is a unique judgment, and it is giving full stress upon the purity of pleadings. And the purity of pleadings is not only in the expressed form, but the concealment and withholding of the material facts as well are covered by this mischief. Therefore, we as liars have to learn enough, and it is much useful as a defense as well, as many times, many times, people conceal, withheld material facts, and once it is pointed out, then it will amount to having been fraud played by the party, and the party is to suffer. Therefore, if we as liars are sensitive, conscious about this particular situation, then this judgment can save us in many grave situations. See, it reads at that the very first sentence, fraud avoids all judicial acts, ecclesiastical or temporal, means all type of frauds are included, and it avoids all judicial acts, ecclesiastical or temporal, means whatever may be the form, it avoids. Observed Chief Justice Edward Coke of England about 3 centuries ago. It is the settled proposition of law that a judgment or decree obtained by playing fraud on the court is a nullity and honest in the in the eyes of law. Such a judgment decree by the first court or by the highest court has to be treated as a nullity by every court, whether superior or inferior. It can be challenged in any court, even in collateral proceedings. So if any judgment or decree stands obtained by playing a fraud, then it is nullity. I think each one of us have this paragraph on our table, on our study table, on our dictation table. Now, the judgment proceeds further on the facts of the case. Predecessor in interest of the respondents plaintiffs filed application for final decree for partition and separate possession of the plate properties and for mezzanine profits. Appellant's defendants contested the application on the ground that a preliminary decree which was sought to be made final was obtained by fraud, and as such the application was liable to be dismissed. The trial judge accepted the contention and dismissed the application for grant of final decree. Respondents plaintiffs went in appeal before the High Court. A division bench of the High Court went through the cloth of case law and finally allowed the appeal and set aside the order of the trial court. This appeal is by way of certificate granted by High Court. The judgment proceeds further. One, Jagannath was the predecessor in interest of the respondents. He was working as a clerk with one Chunilal. Jagannath purchased a court auction the properties in dispute which belonged to the appellants. Chunilal Savkar had obtained a decree and the court sale was made in execution of the said decree. Jagannath had purchased the property in the court auction on behalf of Chunilal Savkar, the decree holder. By registered deed number 20, November 25th, 1945, Jagannath relinquished all his rights in the property in favor of Chunilal Savkar. Meanwhile, the appellants who were the judgment debtors had paid the total decretal amount to Chunilal Savkar. Thereafter, Chunilal Savkar, having received the decretal amount, was no longer entitled to the property which he had purchased through Jagannath. Without disclosing that he had executed a release deed in favor of Chunilal Savkar, Jagannath filed a suit for partition of the property and obtained a preliminary decree. During the pendency of this suit, the appellants did not know that Jagannath had no locus standi to file the suit because he had already executed a registered release deed relinquishing all his rights in respect of the property and dispute in favor of Chunilal Savkar. It was only at the hearing of the application for final decree that the appellant came to know that the release deed, and as such they challenged the application on the ground that non-disclosure on the part of Jagannath that he was left with no right in the property in dispute vitiated the proceedings, and as such the preliminary decree obtained by Jagannath by playing fraud on the court was a nullity. The appellants produced the release deed exhibit B15 before the court. The relevant part of the release deed is as under. Out of your accretions and out of trust vested in me, purchased the scheduled mentioned properties Benami in my name, or court auction, and had the said sale confirmed. The said properties are in your possession and enjoyment. These said properties should henceforth be held and enjoyed with all rights by you as had been before. So far, if any civil or criminal proceedings have to be conducted in respect of the said properties and instituted by others in respect of said properties, you shall conduct the said proceedings without reference to me and shall be held liable for the profits or losses you incur thereby. All the records pertaining to the aforesaid properties are already remaining with you. Now, in this light, the High Court reversed the findings of the trial court on the following reasoning. Let us assume, for the purpose of argument, this document, Exhibit B15, was of the later category, and plaintiff, the Benamidar, had completely divested himself of the rights of every description. Even so, it cannot be held that his failure to disclose the execution of Exhibit B15 would amount to collateral or extrinsic fraud. The utmost that can be said in favor of the defendant is that a plaintiff who had no title at the time when the suit was filed to the properties has falsely asserted title, and one of the questions that would arise, whether expressly by necessary implication, is whether the plaintiff had subsisting title to the property. It was up to the defendants to plead and establish by gathering all the necessary materials, oral and documentary. The plaintiff had no title to the suit property. It is their duty to obtain an encumbrance certificate and find out whether the plaintiff had still a subsisting title at the time of the suit. The judgment proceeds further. Plaintiff did not prevent the defendants, did not use any contrivance nor any trick nor any deceit by the defendants who are prevented from raising proper pleas and reducing the necessary evidence. Parties were fighting at arm's length, and it is the duty of each to traverse the or or question the allegations made by the other party and to adduce all evidence, available evidence regarding the basis of plaintiff's claim or defense of the defendants and the truth or falsehood concerning the same. A party litigant cannot be indifferent and negligent in his duty to play the materials in support of the contention and afterwards seek to show that the case of the opponent is false. The position would be entirely different. The party litigant could establish that in prior litigation, this opponent prevented him by an independent act, collateral wrongful act, such as keeping the witness in wrongful or secret confinement, stating his documents to prevent him from affecting an evidence, conducting his case by tricks and misrepresentation, resulting his misleading of the court. Here, nothing of the kind had happened, and the contesting defendants could have easily produced a certified registered copy of the exhibit B15 and non suited the plaintiff, and it is absurd for them to take advantage or make a point of their own acts of omission or negligence or carelessness in correctness of their own defense. The High Court further held as under the judgment proceeding. From this decision, it follows that except proceeding for the probate and other proceedings where a duty is cast upon a party litigant to disclose all the facts, in all other cases, there is no legal duty cast upon the plaintiff to come to the court with a true case and prove it by the evidence. It would cut at the foot of the fundamental principle of law of finality of litigation enunciated in the maximum interest replicum sit in a sum if it would be held that a judgment obtained by plaintiff in a false case else to his knowledge could be set aside on the ground of fraud in a subsequent litigation. Finally, the High Court held as under the principle of this decision governs the instant case at the worst the plaintiff is guilty of fraud in having falsely alleged at the time when he had filed a suit for partition, he had subsisting interest in the property, though he had already exhibited the 50. Even so, that could not amount to extinguishing fraud because that is a matter which could well have been reversed and established to be false by the applicant adducing the necessary evidence. The preliminary decree in the partition suit necessarily involves an adjudication, though impliedly the plaintiff has a subsisting interest in the property. Now the Supreme Court proceeds further. The High Court, in our view, fell in patent error. This short question before the High Court was whether, in the facts and circumstances of the case, Jagannath obtained the preliminary decree by playing a fraud upon the court. High Court, however, sent haywire and made the observation which are wholly perverse. We do not agree with the High Court that there is no legal duty cast upon the plaintiff to come to court with true case and about it and prove it by the true evidence. The principle of finality of litigation cannot be pressed to the extent of such an absurdity that it becomes an engine of fraud in the hands of dishonest litigants. The courts of law are meant for imparting justice between the parties. One who comes to the court must come with clean hands. We are constrained to say that more often than not, process of the court is being abused. Property grabbers, tax evaders, bank loan lodgers, and other unscrupulous persons from all walks of life and the court press process a convenient lever to obtain a illegal gains infinitely. We have no hesitation to say that a person whose case is based on falsehood has no right to approach the court. He can be summarily thrown out at any stage of the litigation. Para 8. The facts of the present case leave no manner of doubt that Jagannath obtained the preliminary decree by playing fraud upon the court. A fraud is an act of deliberate deception with the design of securing something by taking unfair advantage of another. It is a deception in order to gain by another's loss. It is cheating intended to get an advantage. Jagannath was working as a clerk in a Chunilal Sarkar. He purchased a property in the court action on behalf of Chunilal Sarkar. He had, on his own volition, executed the registered release deed Exhibit B15 in favor of Chunilal Sarkar regarding the property in dispute. He knew that the appellants had paid the total decretal amount to the master Chunilal Sarkar. Without disclosing all these facts, he filed the suit for the partition of the property on the ground that he had purchased the property on his own behalf and not on behalf of Chunilal Sarkar. Non-production and even not mentioning of release of deed at the trial tantamounts to playing fraud on the court. We do not agree with the observation of the High Court that the appellant's defendants could have easily produced a certified registered copy of Exhibit 15 and non-suited the plaintiff. A litigant who approaches the court is bound to produce all the documents executed by him which are relevant to the litigation. If he withholds a vital document in order to gain advantage on the other side, then he would be guilty of playing the fraud in the court as well as on the opposite party. So the word catch sentence is, if he withholds a vital document in order to gain advantage on the other side, then he would be guilty of playing fraud on the court as well as on the opposite party. We therefore allow the appeal, set aside the impugn judgment of High Court, and restore that of the trial court. The appellants shall be entitled to their cost, which quantify at rupees 11,000. So the lesson is that if we are, as plaintiff, invoking the jurisdiction of a court, then it is our duty that we shall file all the relevant documents, we shall give all the information, and we will be having no excuse that other party can find out and place them to non-suit him. A very sentence I am reading again. A litigant who approaches the court is bound to produce all the documents executed by him which are relevant to the litigation. If he withholds a vital document in order to gain advantage on the other side, he would be guilty of playing the fraud on the court as well as on the opposite party. This sentence, this ratio is of such value these days that every fraud, every dishonest intention of every litigant can be brought to the knowledge of the court and he is to be non-suited. Therefore, this judgment shall be read again and again, and lesson should be imbibed well, as that a litigant who approaches the court is bound to produce all the documents executed by him which are relevant to the litigation. If he withholds a vital document in order to gain advantage on the other side, then he would be guilty of playing the fraud on the court as well as on the opposite side. Thank you.